Hi guys, this is Jessica Arthur with Cape Fear Family Law. I'm one of the practicing attorneys here at Cape Fear Family Law. Today we're going to talk about an appellate case that just came out. It's Johnson v. Law Wing. It is a case about custody. Judge Frederick B. Wilkins Jr. originally heard the case out of Surrey County. David Schiller represented plaintiff, who was dad, and J. Clark Fisher represented defendant, which was mom. This case is a published case that just came out on June 20th, 2023. And when we say it's published, what we mean is that this is good law. We can use this law, we can cite this law, we can move forward and keep using it all the time. This case that we're going to discuss today is primarily about a motion to modify custody. There was also a motion to show cause filed that the appellate court discussed, but we're going to focus primarily on the motion to modify custody today. So when we know if someone's filed a motion to modify, we know there is an underlying order. In this case, the underlying order was originally from 2014, and it gave dad primary custody, it gave mom visitation. When we go back and look at the record, there's only been one modification of this 2014 order is what it looks like, and it looks like that was done in 2018. And the interesting thing is the only modification at that time is that mom couldn't have overnights as long as she was living with her parents. So that's very interesting to me, and I almost kind of like to go back and look at the order on that and see what was going on then. But until then, there hasn't been any other modification, or at least there doesn't appear to be any other modifications that were granted. Mom filed this current one that's at issue here in 2021. When we're looking at a motion to modify, it's typically two-prong test. It's kind of a three-prong test if you really look at it, but it's a two-prong test, right? So we're trying to get a motion to modify custody. It's not a small hurdle, it's a big hurdle. The first part of that is, was there significant change of circumstance? Significant change of circumstance is not a minor thing. This is a big thing. This is not changed activities. They decided they like baseball more than soccer. This is not dad moved into a bigger house. These are significant change. That word is not there on accident. And then if we have significant change of circumstance, we have to prove that it has an effect on the minor child. That's an important prong that I feel like some people skip, and in this case was a big issue for them. You have to show the significant effect on the minor child, and that can be positive or negative. We've seen case law that shows previously one of the parents maybe was an alcoholic and they got their life together and they could be a part of the child's life, and now it's a very positive impact on the child. Or clearly it could be a negative impact, right? Like the other side of the hill, they start to slide down and are having major negative impact on the child. So it can be positive or negative, and we need to always keep that in mind when we're looking at a case. If we meet those two prongs, then the court still has to determine, is it in the best interest of the minor child or children to modify the current custody order? So this is not a small hill you have to climb. You can't just go to court because you're unhappy with what's going on. You have buyer's remorse. These are big changes that you have to prove and show when you go to court and try to get a motion to modify. In this case, we're going to look at these facts and take it to that prong test that I just talked about, right? What mom said in this case is that kid was really unhappy at dad's. Kid was saying dad was never there. Dad was treating him differently from his other siblings. It looked like he had some half siblings at dad's house, that he was just really unhappy there, and dad was not spending any time with him. There's also allegations that dad had engaged counselors or other doctors and hadn't kept mom in the loop about those things. Child also says that he really wants to be with mom. He's very clear about that to mom. Mom really harps on that and makes a big deal about this is the child's wishes. The child wants to be with mom more, doesn't want to be with dad, and dad's just not around, not spending time, not a good guy, is how mom really portrays the issues here. And mom also brought up the point that she got a new stable place to live and had been there for a while. So she was also trying to bring up her positive. Mom really wanted the court to focus on the child's wishes, that she wanted that to be weighed very heavily. She wanted that to be where the focus was for the court. But at the end of the day, the court found these things to be true. Dad was home every night for dinner. They had dinner as a family. This was consistent even before the 2018 order. This was facts that were put in the record and no one disputed. Dad was consistently meeting the emotional needs and the educational needs of the minor child. Not only that, y'all, this kid was AB honor roll. This kid had 4 absences from, I think it was kindergarten to like 4th grade or 3rd grade. The kid was never tardy, not once. That's a miracle all in itself. Like, this kid's needs were exceptionally being met. And at the end of the day, dad was making sure that all those things happened because he had primary custody, right? Let's remember that that's what was going on at this time. So this child was doing exceptionally well in school. Apparently at the beginning of school, maybe had some behavioral issues, and those were even declining as he got older. So clearly dad was doing a great job with that. They also found that dad had kid and age appropriate activities. Like, he was doing everything he needed to for this kid. And they also didn't find that there was any evidence that this child was being treated any different from any of the other children in his home. However, the court also found that this child did express his wishes to spend more time with his mom, be with his mom more, and what mom had said, the child had said. The court did find that to be the case. Some of the other undisputed facts, though, were that dad had absolutely got the kid in counseling. There had been some other doctor's appointments that he had not told mom about, at least at the beginning, right? So there was some counseling appointments at the beginning he did not tell mom at. Mom did end up being involved in that counseling for months and months. And the kid was eventually discharged from the counseling because he had met all of his goals, which is awesome. But dad did start that, initiate that, had meetings without mom knowing. He also had doctor's appointments without mom knowing, and that was a violation of the order. Now that we know the facts the judge actually found to be true, and let's take a step back, right? When you go to court, what the judge finds to be true is what you're stuck with come hell or high water. You might disagree with them, want to throw a hell fit, think that they got it totally wrong, and it doesn't matter. That's why maybe sometimes working with your ex, trying to find middle ground, trying to find solutions really is the best way, because these are the facts that the judge found. And at the end of the day, that's all that matters. It doesn't matter anymore what he said, she said. So those are the facts that the judge found. So let's go back to our prongs, right? Like our test. The court did find that there was absolutely a significant change of circumstance. They had met that prong. Check. However, they did not find that mom had proven that there was an effect on the minor child that was substantial, that had a positive or negative impact on the minor child. Even though the mom stressed, like, this child's wishes should absolutely be enough to get me over that hurdle. Court found that she did not cross that hurdle, and that's where her case stopped. And that's where she decided, no, I'm going to the appellate court. And the appellate court, unfortunately, agreed with the district court in this case, for her. But I want to make it super clear when we're talking about child's wishes, right? Children, while they are absolutely little people, are still learning how to be people, okay? So the court said very clearly, without hesitation, that a child's wishes are never controlling. I need everybody to hear that, even everyone in the back. A child's wishes are never controlling. I have people ask me all the time, how old does my child have to be to pick where they live? 18. They've got to be 18. When they're 18, they get to pick where they live when they are an adult. Otherwise, if you, as the parents, can't agree, a judge is going to tell you where the child lives until they turn 18. So let's, again, take a step back and kind of look what the court said, because there's so many factors that go into just going off of a child's wishes. The court was very clear, because a child can be, to some degree, manipulated, right? There was 3 things that they said you should absolutely be cognizant of when you're looking at a child's wishes. One is temporary dissatisfaction. Are there all of a sudden new rules at dad's house? Are there all of a sudden new requirements at dad's house? You got to do your homework before you get Xbox time, or got some new friends that dad doesn't like hanging out all the time like the child wants. Temporary dissatisfaction is absolutely not reason to change custody. The other thing that brought up is a passing whim, right? We all have those. We're like, hey, things might be better over there. Hey, maybe if I do that, I'll get, mom will give me more screen time, or mom has better snacks, or whatever. You should never, ever change custody due to the passing whim of a child. And the third thing that the court looked at was a present lure. I've seen that too many times, right? One parent wants to get a new dog. One parent is going to get the brand new PlayStation 5 right when it comes out. One parent's going to get a pool. These are all examples I've actively seen. So the court was super clear. Neither of those 3 things are ever grounds to change, and courts need to be aware that that could absolutely be why a kid's basing their wishes, their desires on, and when they express that, that could be what's behind that. So a court was super clear. A child's wishes, while they can absolutely be considered at the discretion of a court, are never controlling. Dad won, y'all. Child custody stayed the same, mom still gets her regular visitation. But I'm really interested to hear from you guys. Please comment below and tell me how you think a child's wishes should be weighed or considered by a custody court. Please like, subscribe, and check us out next time.